The Platters were a popular music group formed in 1953. They were a dominant group in the 1950s, but they've continued to tour with an evolving lineup until this very day. Their name has often been ripped off by other groups calling themselves the Platters. In 2007, a group calling themselves the Platters was booked to play at a casino in Atlantic City. The state, concerned that this was not the authentic group, intervened. The managers of the group sought a temporary order restraining the state from interfering with the concert. The state complied, the concert went ahead, and so, well before any trial, the dispute was resolved. The real question at this point was whether the managers were entitled to their costs. Under the relevant statute, they were entitled to costs if they prevailed in the proceeding. The majority judges found that they had not prevailed because there had not been a contested trial and judgment. 4 dissenting judges argued that a party had made an application and the result had been exactly the remedy they wanted, so they should get costs. Judge Roth relied on some of the most important writings of jurisprudence. His key point was that judges should not simply make procedural assessments when the justice of the case went in another direction. He said, if, as in cases like this one, the law is not clear, the courts are faced with what Professor H.L.A. Hart called the penumbral issues, where the language of the legislation is general. Whether a judge attempts to clarify a penumbral area of the law reflects a value judgment and is indicative of the judge's jurisprudential temperament. Some judges have lower thresholds than others and are more inclined to find solace in shades and fringes rather than the black letter law. When this problem occurs, Professor Ronald Dworkin suggests that the decision depends on the judge's own preferences among a sea of respectable extra-legal standards, any one in principle eligible. Because if that were the case, we could not say that any rules were binding. This is a slight misreading of Professor Dworkin's view, which is that in making such decisions, a judge should look to the underlying legal principles rather than making an idiosyncratic decision. However, this remains a decision where a judge, confronted with a challenging decision, looked to the most significant writing in jurisprudence.